In 3, 2, 1.
Продовжуємо засідання.
Let's continue our meeting. Please invite Ostapenko Dmytro into the room.
Добрий день.
Good afternoon.
Задається питання щодо відповідності кандидата на посаду.
We are considering the issue in terms of compliance of Ostapenko Dmytro with the criteria set out by Part 4 of Article 8 of the Law on the High Anti-Corruption Court. We have members of the PCAE present, Robert Heinbruch-Hassen, Chair of the PCAE, Norman Oz remotely, Mary Kate Badler remotely, Gabriel Yotkaida-Hetkene, John J. O'Sullivan, and Jessica Thompson. Members of the HQCJ, Mikhailo Bogonis, Людмила Волкова, Роман Кадисюк, Наталія Кубецька, Олег Колюш, Ігор Кушнір, Руслан Мельник, Олександр Молян, Сергій Чумак, Олена Шевчук, and others. You have a right to request recusals, to provide explanations upon the permission of the chair to express your objections, to challenge decisions following the instances set out by the law. Do you have any recusal requests? Mr. Chair, I have no recusal request, but I would like to inform information that might be interesting for members of the PCAE and the HQCJ. In view of the fact that I was a member of the Public Integrity Council in 2019, there was ongoing competition for the position of judges of Anti-Corruption Court. Chimak Serhiy took part in that competition. I was the co-rapporteur regarding his candidacy, and accordingly, I voted for submission of the decision to the HQCJ regarding information about Serhiy Chimak. I do not believe that this can cause doubts about his impartiality, but I consider it as necessary to inform that, because at the website of the PIC, you have the text of this decision, the minutes of voting, which shows my voting. I have no other information about that, and I have no recusal request. Okay. Was it information or conclusion? That was decision on provision of information. It was not a report. Okay. Okay. Colleagues, as far as I know, Serhiy is being delayed now because he is the secretary of the fourth chamber. He's finalizing some documents right now. So I'm announcing a technical break now. We will get in touch with him so that he could come here and maybe Thank you. Okay, in order to save time, we will move on to the stage of announcement of the presentation of the candidate, and I hope that by then Mr. Serhiy will come back and we will ask him about his position regarding this information that the candidate has just announced. Okay, the core report, no other informations, no other recusal requests. No, Mr. Chair, none. Okay, the core reporter is Koleusz Ola. Please, the floor is yours. Thank you. Good afternoon. With the decision of the HQCJ dated June 3rd of 2025, there was announced competition for filling in 23 vacant positions of judges of the Hague and Appellate Chamber of the Hague. Within this deadline, Ostapenko Dmytro has submitted his application for participation in this competition for the vacant position of the Anti-Corruption Court of Ukraine as the person who complies with requirements of Part 3 of Article 7 of the law of Ukraine on the Anti-Corruption Court. With respect to the conduct of qualification evaluation, with respect to him regarding his capacity to administer justice. With the decision of the HQCJ dated September 16 of 2025, Ostapenko was admitted to qualification evaluation and participation in the competition. With the decision of the HQCJ dated September 19, there was appointed qualification evaluation for filling in positions of judges of the Hague. With the decision of the HQCJ dated September 19, there was appointed qualification exam and the order of its stages was decided. And with the decision of the HQCJ dated February 4th of 2026, results of the exam were and the candidate got 363.83 point, and he was admitted to the stage of the interview qualification of the candidate. In 2011, Ostapenko graduated from National Law Academy of Ukraine of Yaroslav Mudry. He got full legal education and the legal studies and obtained the lawyer's qualification, and he has no PhD status. In 2011-2012, he served in criminal police. In 2012-2013, he worked in the position of the legal advisor of LLC Premier Legal Consulting. In 2013, he was registered as individual entrepreneur. His main type of economic activity is activity in the sphere of law. On March 23rd, of 2017, he got his attorney's license. Besides, according to information from this year, throughout 2018 to 2020, the candidate took part as a member of the PAC during the conduct of qualification evaluation for selection to the Hague. In 2021 to 2023, he provided assistance in reforming of prosecutorial bodies as a member of the Attestation Commission, as a member of personal commissions for attestation of local and regional prosecutors' offices of the Office of the Prosecutor General. In 2022-2023, he also performed functions of the commission member for the selection of the head of ARMA. And in 2023-2024, he performed duties of a member of the Anti-Corruption Council under the Ministry of Defense. He was a member of the Task Force on Assessment of Corruption Risk. Dmytro Ostapenko is fluent in the state language. He fulfilled requirements regarding advanced training for attorneys. In 2019 to 2023, he submitted the Declaration of Family Ties, the Integrity Declaration, and the Declaration of the person authorized to perform functions of the state or local self-governance. During the competition, the Commission sent requests to SGA, Security Service, Office of the Prosecutor General, State Border Service, NACP, National Police, NABU, Ministry of Justice of Ukraine, as well as other public authorities, and we got respective responses from these public bodies. That's the end of my report. If everything is correct, I have not made any mistakes. Probably, mostly, I'm asking about your professional activities. Very good report. Thank you. Everything is correct. Okay, thank you. Since probably we cannot continue the interview without Mr. Serhiy Chumak, if there are no other suggestions, I think we should decide on this position of Mr. Serhiy before we move on to questions. So if there are no other suggestions, I'm announcing a technical break. Let's wait.
Відновили трансляцію. Пане Дмитро,
We
у мене буде
resume
до
the
вас.
broadcast. Mr. Dmytro, I have a request to you again to repeat the circumstances that you've just voiced.
Я зрозумів. Так, пане голово,
Okay.
ще раз повідомляю.
Yes, Mr. Chair, I'm informing again that while being a member of the Public Integrity Council in 2019 during the competition to the HOC, I was a rapporteur regarding the candidacy of Serhiy Chumak for the position of the judge of the Cassation Criminal Court of the Supreme Court, and I prepared information regarding this candidate. I voted for that decision, and this information is available at the website of the PIC. But I respect Mr. Serhiy as a specialist, but I suggest wanted to inform this publicly.
Відповідно, Сергій Юрійович, ми-
Okay, then accordingly, Serhiy, we waited for you to clarify. Maybe you have self-recusal grounds. Thank you. Sorry for this delay. That's news for me. I did not know about that because, as far I remember, during my interview during the competition to the Supreme Court from PIC, during was Sokolenko Natalia and Maxim Saradan was present at the second interview. That's news for me. I did not know about that. I didn't know that the candidate was the co-rapporteur because I've mentioned which PIC members were present at my interview. But no claims, no problems, of course. Again, I would like to repeat again that it's news for me. I did not know about that. So obviously, there are no grounds for self-recusal, right? Yes, none. I think that we met with the candidate once at the anniversary of the previous composition of the PIC. Yes, that's correct. There were many members of the HQCJ. Yes, as far as I remember, that was the only event where we came across each other.
Це з'ясувати.
Okay, we just needed to clarify that. No impartiality regarding the candidate. I believe that I can objectively take decisions about him. Okay, thank you.
Відповідь була вже
Okay, then.
озвучена, відповідно, передаю.
Accordingly, I am passing the floor to Mr. Robert now. Please, the floor is yours.
Thank you, Mr. Chairman. My name is Robert Broekhuizen. I'm the chair of the PCIE, but I'm also the rapporteur in your case. And the first question I have is the following. You have stated in your motivation letter quite some examples of corruption you have faced. You remember that, huh? For instance, you have written that you refused a few clients because they want to have the issue resolved by corrupt means. I will not discuss this because I guess that you're bound by secrecy and privilege obligations. But also you mentioned that you stopped communicating with several colleagues who wished to have assistance in passing the qualification assessment when you were a member of the PIC. Yes? I'm interested to know from you what your reaction was and when those colleagues, which I guess are lawyers, attorneys, came to you and asked you for assistance. What did you do?
Thank you for your question. Indeed, such situations happened to me. What was my reaction? So, from the very beginning, from the starters, when I realized what this conversation would be about, that I would be suggested to participate in certain illegal activities, I just stopped such conversations immediately. And regarding those colleagues who try to talk to me like that, I just stop communicating with them forever, not only as with colleagues, but also with human beings, because I evaluate such people as dangerous for myself and for my further career, but because as an attorney, I'm also burdened with certain cautiousness regarding the attorney's ethics. I cannot share the essence of such communications. I cannot participate in cooperation with law enforcement authority in order to progress such communications further, to put them into the foundation of further criminal proceeding against such a person who tries or wants to suggest illicit profit. So everything what I can do in such a status, in such a role of attorney, I can stop such communication immediately, underline that it's not appropriate, unacceptable, and illegal, and that's all what I can do.
So you feel that just stopping communication would be sufficient from out your position in the PIC? For instance, did you inform your other members in the PIC of this?
In my work, when I was a member of the PIC, with my colleagues, we were constantly in touch, in communication in our internal chat, because physically we didn't meet very often. At that moment, I lived on the permanent basis in Kharkiv, but we were in constant touch regarding our work. And for many times, we have discussed how we shall behave in such station, how we shall respond to such provocations, to such calls for action. So in internal circle, we have discussed such issues together with my colleagues. Even more to say, as far as I remember, there were such cases, not in my practice as a PIC member, but I think that some PIC members even reported such information to the HQCJ regarding such attempts, either from judges or their representatives, to communicate on potential qualification assessment. So if that was...
I would request you to answer concise. What I asked you is whether you shared the information that you were contacted by colleagues with the other members in the PIC, that you have discussed it in general. I can understand. But the question is, did you communicate? Mr. A, Mr. B, and Mr. C contacted you to help them to the other members of the PIC? And if yes, I would like to hear, and if not, I would like to hear why not.
Здається, перекладач завершив переклад.
I think the interpreter finished interpretation. So in such cases, as far as I remember, I reported such information. All this information is stored in our internal chat, which we used a messenger app. So as far as I remember, I always communicated this information to my peer colleagues.
Very good. And let's say that you are a hack judge, and this would happen. Someone would contact you, you have an attorney, you have all kinds of clients, you know many, many people. What would you do if someone comes to you for assistance?
Я просив би вас уточнити питання.
I'll kindly ask you to clarify your question in the following context. So someone approaches me to help. As an attorney, as a representative of the PIC, or as a judge, I just didn't get your question. Okay, clear. So, if it happens that I become a judge, in such cases, we have legitimate tools envisaged by legislation. What shall be done? A judge could and actually obliged to report about any cases of such interference into their professional activities to the High Council of Justice. And if it happens that I become a judge, and indeed such case happens, I will definitely do it. I will report to the HCJ, and I am inspired by those judges who report to the HCJ about potential interference in their activities.
Thank you for that. I would like to discuss, and of course you will remember that that's the competition of the head of the ARMA, A-R-M-A, yes, which is the management of the assets derived from corruption, yes, which means proceeds of crime, yes. And I understand that ARMA is quite an important institution in Ukraine, And I understand you have been a member of the competition commission, like we are a member of this commission. It's correct. Huh? Can you tell me who who nominated you in this position?
Дякую за це запитання.
Thank you for this question. I'm happy that we will be able to discuss this episode of my biography. I was nominated for that position by the former Prosecutor General Andriy Kostin.
Okay. And I guess that when you were in this commission, you were not the only one. I believe there were 8 members, huh? And,
Це правильно.
yes, and
Yeah,
there was
you're
also
right.
a secretariat, I guess, similar like we have.
Так, там був секретаріат на кшталт тої.
Yeah, there was a secretariat as a working group here with which we cooperate.
And it was funded by donors, most likely.
Наскільки мені відомо, так.
As far as I know, indeed, this secretariat was established with support of international organizations. You can call them donors, yes.
And am I right to think that when you were in this position, you would be provided with information about the candidates by the analysts, like happens with us as well?
Це абсолютно коректно.
Yeah,
Yeah,
you're
that
absolutely
means
right.
That when you would have a candidate, you would be quite prepared.
Дуже і дуже.
Yes?
Yeah, very, very.
And I understand that in the end, there was a candidate called Olena Duma, and she was voted for by the commission. And am I right to understand that on basis of the vote of the commission, this individual, as the selected person, would be appointed by, I believe, the Ukrainian parliament or the
Вибачте, ні, призначення
No, not
відбулося.
sorry, not appointed. No, she was appointed by ministers of
Okay.
Ukraine based on recommendations of us.
Yes, and what I have seen is that when that happened, and she was appointed and she was elected, quite a stir occurred. That's correct, huh?
Так,
And I've also seen
Yes.
that after that, you said, I withdraw my vote on this selection.
так, це правильно.
Yes, yes, it's true.
And you say that the reason, if I'm not mistaken, or maybe you can explain the reason why you did this.
Так, я можу пояснити.
Yeah, I can explain why.
Please go ahead. Please explain.
Дякую. Одразу хочу
Yeah,
попередити, що відповідь
Yeah,
на це
thank
питання
you.
займе не
And
менше 3
again, it will take up to 3 minutes, not less than 3 minutes to explain it. So the issue is when we were voting at the final of this competition,
Так, так, так. Треба цю історію розділити на дві.
yeah, so this story shall be divided into several parts. So the procedural part, how we voted and how and what decision was made according to the rules of procedure of the competition, and the individual personal part regarding information about this candidate. I will start with the second one. So with the individual part of regarding this candidate. When I voted for different candidates for the position of the head of the arma, I based my decision on information from profiles of these candidates that I had at my head, information collected by the working group, and information which was available for us from different public authorities. Part of this information was given to me through sending these documents to my personal email, and I had remote access to it. Another part of information, sensitive information, was stored at the computer. It's a computer and the server maintained by the website of the Communist Administration of Ukraine. So regarding Olena Duma, the profile prepared by the working group members contains the following information. So there were many different pieces of information, but the following wording was included there: that this candidate is subject to the pre-trial investigation of the NABU and allegedly her involvement into certain events. But this information was not corroborated or accompanied with anything at all, with any documents, criminal case files, and so on. As a professional lawyer, I just took this information into consideration as just as information, but it was not corroborated by anything. That's why it was not possible for me to use this information for my future decisions. Later, during my communication with my colleagues, including other competition commission members nominated by the international organizations, and I clarified that information which was published at the website of the Ministry of Ukraine, there was information regarding this criminal case. I cannot share this information right now because this criminal proceeding, as far as I know, is still ongoing. The verdict has not been yet made in that criminal case, and information which is there in that criminal case is extremely sensitive, and I didn't receive any permits to share information about it, because according to the CPC of Ukraine, only an investigator is allowed to share information about pre-trial investigation. And as this investigation is still ongoing, I think that I'm not allowed yet to share any information about Elena Duma. She has her own reputation, dignity, and so on, and I can damage all this. But at the same time, for me as a commission member, when I found out about this information, indeed, it overwhelmed me. And when I clarified this information, I realized that I would have never voted for this candidate if I had known about this information before. Then, regarding the first part, procedural part, according to the rules of procedure, 8 commission members have a right to vote only for one candidate. And on the day of a final official session, with a decision for a winner of the competition, we started voting using ranks, when each commission member was allowed to give unlimited number of votes for a limited number of candidates. I think I voted for 5 or 6 candidates whom I considered as the ones who were decent to take this position. Before we started that streaming of that official session in Zoom remotely, we discussed with the commission members that after this ranking voting, we are going to have another voting where actually we are going to vote for 2 finalists with highest rankings, where each commission member will have a right to give their final vote. But I was surprised when the ranking voting took place. The head of the commission announced that we have a winner. My mistake was that at that moment, because of lack of experience, and I will be open with you, that it was my first experience of participation in such processes, in such political process, let's call it so. I didn't pay attention to it. And only afterwards, after the session, at the end of this official session, maybe in an hour, I realized that how we voted, actually, it didn't comply with provisions of the rules of procedure of the competition. And I looked again and again through the rules of procedure. And when I realized that the voting actually took place in a wrong manner, and I didn't have all the information as of moment of the voting, I decided to submit an application to withdraw my voting. And the only possible option to do it is to call the extraordinary additional session, because the final protocol, the final minutes of the session shall be signed, and only then the decision is considered to be made. So I tried, I failed, and indeed it was my mistake because of my lack of experience. I apologized in front of the public. I made several Facebook posts, and I have my lessons learned based on this situation.
Thank you for your explanation, but I would like to take a bit step for step. What I understand is, if I, let's say, put it together, is that you say that when you voted, that the procedure was incorrect. Is that correct to say that?
Так, вийшло, що процедура була некоректна.
The procedure was incorrect.
Yes. Can you maybe put it on the screen, number 1? This is the voting, huh?
Так, є.
And didn't the
Yes.
voting go as it always goes, which is at first the chairman describes what's on the agenda, the voting for one person, and that after that the voting takes place. Is that correct?
Трохи не так. Ми йшли,
Not specifically. No. The chair went through the list of finalists one by one. And when the surname was announced, and I think surnames were announced in an alphabetical order. So names of each candidate were announced, and each commission member had an opportunity to raise their hand and vote for this candidate. So in such a way, the commission members raised their hands several times, voting for their favorite candidates.
But was the way of voting not agreed in advance, and you agreed to the agenda of the voting?
Порядок денний був
The
надрукований
agenda
тільки у
was published and it was available only for the chair of the commission. Maybe it was printed. I don't know. Maybe it was printed out or not. I was in Zoom. I did see it in paper or at hands of the chair of the commission.
Okay. And clearly you voted in favor after having seen the information that was provided to you. And I understand that you say that in the information provided to you, there was no information available apparently regarding a criminal investigation against this Mrs. or Mr. I don't know. Mrs. Duma. Is that correct?
Yes.
And you were not aware of, let's say, information about her that could raise quite some concern?
Так, ще раз, я бачив інформацію про те, що
I saw information that allegedly there is a criminal proceeding in her profile prepared by the working group. That's a similar profile that you have on me. So this is genuine information, but this information didn't contain any reference to any specific file, any specific folder, letter that I should have found it and familiarized myself with.
And when you were voting, I guess that you did this independently because you were, like all of us, acting independently. Maybe I'm asking my help to put up the Facebook post.
Так, це мій допис у соцмережі Facebook.
There's your
Yes,
Facebook
that's
post.
my post in Facebook. Yes, that's my publication. Yes.
And then the first line says, I understand in translation that I consider myself a representative of civil society. The opinion of this society is decisive for me. And in addition, I believe that the trust of respected international and national public organization in the candidacy of the head of such a critical anti-corruption institution of ARMA is great importance. And then it says, that is why I withdraw my vote for Elena Duma. Is my translation correct?
Так.
Yes? Okay. And then my question to you is, that listen to you, I don't understand this because you voted for this person. And then, apparently there was quite a lot of things happening. And then you say, I'm a representative of civil society. And therefore, for that reason, I withdraw my vote. That means that you apparently find decisive, my words and not yours, that what civil society does is what you do. Or do I read that wrong? So what do you mean with the first sentence?
Так, я можу пояснити.
Yes, I can explain.
Річ у тім, що
The matter is that
у нас, я не хочу узагальнювати, скажу.
I don't want to generalize. I will talk about myself. It's very difficult to admit my mistakes. Very difficult.
Тим складніше їх визнавати, коли
And it is even more difficult to admit that mistake when you are making that mistake while being in some very responsible mission that is very important for the society. In this situation, I could have ignored it just like all the other commission members did. I could have said that everything was correct. I voted for her, while being aware of all the information about the candidate, and that I did not care that G7 ambassadors expressed concerns about this candidate being selected, that I do not care what the reputable civil society organizations are saying, who are watchdogs in this side. I could have done that, but I felt ashamed because, as I think, I did not do my job. I should have been more thorough regarding all of those documents that were provided to the Commission, and I could have had at my disposal as of the moment of the meeting. And with this publication, I wanted to emphasize that since I'm associating myself with the civil society, it does not matter that I was delegated to this commission by the Prosecutor General. I felt and continue feeling myself as the representative of the civil society in that commission. And since I felt my obligation to explain my behavior, to point out that I'm not satisfied with how it happened, I decided to do that publicly and to appeal to those for the sake of whom I was in that commission, to the representatives of the civil society.
Yeah. You will understand my next question, I guess, because you are a candidate of the Hague. You want to be a judge, and you want to rule on cases which are very important and will be viewed at by civil society organizations. But let's say that you take a decision in the Hague chamber and you voted in favor, or you discussed with your colleagues to take a certain decision as Hague judge. And after that, there will be an uproar, and there will be publications in the news about that this was all wrong or right or whatever, and or you were provided confidential information by one of your friends. Would you then also withdraw your vote?
Я дуже дякую за це запитання.
Thank you so much for this question, because I'm thinking about this question all the time after the situation, because it's very logical. And now I will give you my answer after a year, because I'm really thinking about that all the time. So my answer will be the following. When I'm doing my legal job as a specialist in the sphere of law, as an attorney specializing in criminal cases, I work according to a very clear step-by-step procedure. I know which evidence the prosecution party has. I know which evidence I have. I know which material the judge has. I know which evidence I should be appealing to, which evidence I should try to prove that they are not very important for the criminal proceeding. And the same situation is in the court. The judge is working according to a clear procedure. The judge has a criminal procedure code where it is clearly stipulated what should be done by judge step by step. And that's how the work of the judge, of the attorney, is significantly different from the work of the commission member, who has to rely on own convictions, own worldview, where the rules of procedure of the work for commission members are quite general. It does not contain provisions and paragraphs that regulate crisis situations. Besides, while adopting the decision, the judge has sufficient time to consider everything. And that's why there is such a tool as the deliberations room, which is kept in the criminal proceedings. When, after listening to everyone, after listening to the defendants, to all the arguments of the parties, the judge is going to the deliberations room to consider everything again and to draft a court decision. And the most important thing is that in the process of drafting of the court decision, when you are preparing your thoughts in the form of text, I do not know about people, but for me, it really helps in life. While I put my thoughts on paper, I at once see some logical inconsistencies, some points that I have to consider more.
The point is that, yes, as I look at it, also the PIC had rules, and they called rules of procedure. And we take, as commissioners, lots of time to design these. And those rules contain rules about voting. And being a judge also have rules, and they are in the code of criminal procedure, I guess. And still, also there is a procedure. And also there, at a certain moment, something may happen. And the point is, of course, that then saying, I withdraw my vote as being a harsh judge, has consequences like it has now. Can you see that?
Так, пане Роберте, я вважаю,
Yes, Mr. Robert, I believe that in the work that is legal work, that is stipulated by clear procedures, this behavior is impossible. The judge cannot withdraw his vote. Moreover, another aspect that I would like to emphasize is that the judge has assistance in the form of judges of higher instances. So while being a judge of the first instance, the judge can count on the fact that even if the judge is making some mistake, it can be identified in the higher instance and it can be corrected. And when I was working in this competition with respect to Ms. Duma, the procedure was more political than legal. And basically, there was no one to correct the mistake. I hope that the government, at the very least, looking at my argument and considerations regarding violation of the voting procedure, would do something, would respond somehow. But the government did not do that. So actually, that was impossible to correct this mistake. And I wanted to be honest and open, or at least to try to do something that I could do in order to draw attention to this and to at least somehow to try to correct that. So in judicial work, that's happening in a completely different manner. And I can absolutely confidently and surely tell you that if I become a judge, I will never make a similar mistake.
Okay, thank you. When I think about it, and of course having the experience in our commission, or in several commissions, when there are issues, I get a profile from Secretariat. And it also contains information that we obtain from NABU. It contains information we get from NACP. And it contains information we get from civil society. I don't know anything about this Mrs. Duma, but I'm quite sure that in the profile about this lady, there would have been remarks about her behavior. And I know that 2 people in the commission voted against her. So, yeah, then I find it so difficult to understand how you came to this reaction.
Sorry, Mr. Robert, if possible, can you repeat the question a bit? Because I am a bit out of the context. I did not catch it. Can you repeat it?
What I try to say is that from my experience in these commissions, we get information from our secretariat that contains of information from all kinds of files. And in any case, and that will be the same in ARMA, I'm sure, it will be information about received from NACP, from NABU, from civil society, and from open sources, and from whatever file. Yes? And I'm sure, if I look at this individual, this candidate, there must have been information about her background and the issues around her.
Mm-hmm.
So what I try to say to you is, you must have been aware when you voted that there were issues with her. Yes? So that means that first question, of course, why did you vote for her and what changed?
Mm-hmm. Я хочу пояснити, що
I would like to explain that those documents that I had at my disposal included a statement from the Ministry of Internal Affairs, which is an official document about the fact that as of the moment of participation in the competition, but Ms. Duma is not being brought to criminal responsibility, that she did not have any procedural status. I had a working profile prepared by working groupers. I did not know members of the working group. Contrary to you, you have an opportunity to communicate and see them. During that process, I did not even know the entire list of civil society organizations, donors responsible for the working group. I know that there was Transparency International, but I did not know who else was there. So I could not have communication with that working group. I cannot recall whether we had a working chat with them or no. I cannot recall that because in several procedures in which I took part, these working chats either existed or not. But I know that I had no personal communication with members of the working group. So those documents which I had actually gave me an opportunity as a lawyer to absolutely surely say that this person is not being brought to criminal responsibility at that time. The phrase that she's mentioned in the criminal proceeding, in our criminal procedure code, we do not have this notion of being mentioned. And that's the notion that is widely used in the mass media in our country. But I'm a lawyer. I have to think in categories that are clearly stipulated by the law. And if the person is not a suspect, is not a defendant in a criminal proceeding, I cannot state that she can be affiliated or not affiliated to the crime. So, but that file that was found later on the computer of the Cabinet of Ministers, which I had no right to take out from that office room because that computer had no access to the internet. And there I found this information, percent result of investigative actions. And that particular information became decisive for me. I do not know why the National Anti-Corruption Bureau of Ukraine has not done anything yet with this information following the official procedure.
Thank you for your answers. I finished my questions. Mary Norman? No? Back to you, Mr. Chairman.
Дякую, пане Олеже.
Thank you, Mr. Olah. We have received appeals from civil society organization after Maidan and some other reports. So I will raise those questions that I have pursuant to analysis of these appeals, as well as while studying the materials provided by you. In your explanations in response to requests of the PCIe, you are stating that in 2020 you got a loan in the amount of $25,000. You are specifying the person from whom you borrowed this fund. I will not name the surname. And at the end of 2020, you repaid a part of unused funds at the amount of $9,000. At the same time, in your declaration for 2020, in section 13, financial commitments, you are specifying the loan of $25,000. Can you please explain this? Yes, Your Honor, I can explain. The matter is that the declaration for 2020, its form back then, was different from the form that exists nowadays. In the declaration for 2020, in section 13, if I'm not mistaken, financial commitments, it allowed reflecting only general information about the loan, date, information about the lender, amount of the loan, and I think that's it. Then the form did not give me a chance to reflect information about the repayment of the part of that loan, as it can be done now in the current forms of the declaration. Back then, I consulted with my colleagues of what I should do. There were two options: either to specify that I took the loan of $16,000 or to reflect as it is. I chose the second option. Why? Because in the declaration, I had to specify the date of the loan. It was January 24th of 2020. As of that particular date, I borrowed from Krolovetsky Igor. That's not a secret. I borrowed from him $25,000. That's why I declared that amount. Unfortunately, the form of the declaration for that year did not give me a chance to specify that I repaid some part of the loan during that year. That was my logic. So as of the date of filling in, you repaid $9,000. Okay, so as of the last date of the reporting period, you repaid $9,000. Yes. Okay. In the candidate's application, you specified that you were a member of all Ukrainian associations for Boda and that you had the legal service of Donetsk, branch of Svoboda. Since 2015, you have been without the party, and in 2014, you were the candidate for the position of the members of the parliament from Shakhtar. The election did not take place because of occupation. So, what encouraged you to join the political activity, and why you decided to stop it? Thank you for your question. Since my school age, I have such a feature as leadership. I was the president of student locals of governance. Then that's the style of my life. I want to be involved into those processes that are taking place in the country. When I lived in the Donetsk region, it was 2013, 2014. That started even before the Maidan, actually. You probably remember those political events in which we lived. We lived in quasi-dictatorship context headed by Yanukovych. And back then I was very concerned what was happening in the Donetsk region in terms of strengthening of Russification, in terms of processes that subsequently facilitated development of separatism. And back then I saw that the only effective political party that had hub in the Donetsk region was Party Svoboda. I met at one of the events, that was an event of commemoration of members of the victims of Holodomor. And that was very principled and very important, that in my town of Shakhtar, this commemoration would take place. And I think only 5 or 10 people came to this event. And for me, it was important to be at least one of those people who would demonstrate in that town that we remember about Holodomor in Donbass. And there I met the head of the local organization of Svoboda, who organized this public event. We had a conversation. We got acquainted, and he suggested to join activities of that political party. And then I asked, what were you doing at Donbass? Can I see you in some active measures of political fight against what was happening in Donbass? Yes. And he told me, we are organizing that and that and that. I got interested. I started cooperating with them gradually. They found out that I was a professional lawyer. So gradually, step by step, I became a member of this community and started cooperating with them. And I believe, and still believe, that as of 2014, in the Donetsk region, the only really active political party with a pro-Ukrainian democratic position was Svoboda, because the motherland political party actually did not work there. And the representatives of our Ukraine, Samokomich, as it turned out later on, that the heads of local organizations were relatives of political party regions. So the only people who were fighting for the Ukrainian idea in the next region was Svoboda. And why did you stop? I stopped my activities because, as I described in my answers about, I had problems with my health. I could not, after in 2015, I was undergoing treatment, and I actually could not do the work that was people would want to see. I could not submit claims. I could not challenge decisions on apprehension of political party members. That's firstly. I just decided that I was not bringing any benefit for this organization. And secondly, back then I decided for myself, after all of the events of 2014, after getting threats, when I was candidate for the MP, and I was threatened with death in the Donetsk region, and I decided to focus on legal work. I decided that I would subsequently work more professionally. I wanted to become an attorney, and actually that's was the end of my connection with politics. But as all citizens of Ukraine, I'm also concerned about some events. I vote at elections, but that's it. Do you now keep in touch with political activists, parties? The last time, I think it was in 2014, in March, That was when I met political party members, and that's since then, no. You know, what's the problem? The head of the party organization of the Donetsk region died. Many people with whom I communicated, they died at the front line. I will not ask you as a judge and to oblige you to say yes or no, but please, I will answer. Since March of 2014, I stopped communication.
And if you're appointed as a judge and you receive a case for consideration, and this case is related to this or that political activist, political person, or party activities. Thank you for a question based on the practice of the of the court, and I have this honor to practice and to work there from the very beginning and observe how the practice has been formed and established. And if it happens that the party to the proceeding is a person or I know, or there are could be certain situations which could raise doubts regarding my impartiality from the side of the external observer, I have a right to submit a self-recusal. It will be considered by my colleagues if that's, of course, a panel consideration of case, and the decision will be made. So you are going to submit a self-recusal? Yes. Major part of issues regarding you that we received from the CSOs, and again, I will repeat that Transparency International and Automaidan, major part of the issues we have clarified during the part of interview when you were asked by the PCIe members. And I have one more question left, and that's related to the attorney's license, which you have received, and the Automaidan CSO says that according to your questionnaire, you were registered at Shakhtarsk settlement, Donetsk region, but the attorney's license you received in another settlement of Ukraine in the Poltava region. So can you please comment upon it? Why did it happen? Yes, yeah, I'm happy to explain. I'm still registered at Shakhtarsk settlement Donetsk region. It's important for me. In 2016, when constitutional changes took place and on introduction of so-called attorney's monopoly, I understand that if I don't, I realize that if I don't get the attorney's status, I will not be able to present interests of my clients in different courts, different instances. So I realized that I need to do it. In the first half of the 2016, the bar council of the bar qualification disciplinary commission of the Donetsk region, they didn't perform their functions. So I was not able to submit my application to that branch in the Donetsk region. And that's at that moment I lived in Kharkiv, and I reached out to the Kharkiv region with asking me to give a permit to allow me to participate in the qualification exam. And the most interesting thing started here. So I applied as a private entrepreneur. I confirmed my status as a private entrepreneur. So they told me that I didn't provide detailed information regarding all the contracts and providing to them. So I need to provide them with a detailed description. I came and provided them with a detailed description of all contracts. Then they told me that I need to provide a relevant pension fund certificate that all pension taxes were paid. So please be more concise. Yeah, of course. So all obstacles were put in front of me in the Kharkiv region. And when I started asking why, I was told openly, you will never pass the qualification exam if you are so smart. And then my colleagues advised me to reach out to the Poltava region Bar Association branch, because their colleagues are more adequate in treatment of different candidates for attorney's license. You know, I am an ITP and I can change different location. So I just went to Poltava. I received an ITP status. Had lived there for a few weeks. I submitted documents to the council. They were checked. I was admitted for the qualification exam. I passed it and received the attorney's license. And I'm so thankful to the Poltava colleagues that they treated me with understanding of my situation. Yeah, also there is another situation. That you have received another case, you have received income from Krolevetsky and Partner law firm. So it says that you have worked with them since 2017 to 2025. but according to tax reports, you received income from them only during 2023. Official income from this law firm. Yeah, I can explain. So first of all, I had never been a member of this law firm, law association. I worked with them only on partnership foundation, and according to the relevant legislation, they engaged me in separate cases, and that's how we worked. Secondly, this information and the income report, and official income received from the Krolovatsky and partner law associations, that's income received under agreements, under contracts concluded with this specific law association when I provided specific legal services, a part of representation of interests of clients in courts and their defense in criminal cases. I provided also different consultations, concluded agreements. So a lot of work has been done by me. So the income which I reflected there in that tax reports, this is the income which I received under the agreements concluded by me, between me and this law association. All income which I received as a private entrepreneur was declared and reflected correctly. Thank you. And I'm going back to the question which Mr. Robert asked you to follow up regarding this Duma case, regarding voting. What about rules of procedure of this competition commission? So first of all, was there any rules of procedure at all? Yes. And was it envisaged by this rules of procedure to arrange a meeting session? So did you violate the rules of procedure? No. Please explain. So in contradiction, so I meant that I needed to do something in violation or what was banned, but it was not banned by the rules of procedure. So I didn't act in contradiction to the rules of procedure. So it means that if it was envisaged that it's impossible to have a session, so you saw it as an opportunity to call a meeting. So I thought that it was, there was sorting a legal gap on how the competition was arranged. Is everything okay? Sorry, let's. Does it work?
В ефірі?
Are we live again?
Дякую за відповіді надані.
Thank you. Thank you for replies provided by you. I have no other questions, dear
Пане Микола,
colleagues.
будь ласка.
Yes, please, Mr. Mykola, over to you.
Технічні перешкоди для задати питання. Пане Дмитре, питання наступного місця.
So I have the following question to you, Mr. Dmytro. The competition commission where you worked and where you made a decision regarding the candidate. Unfortunately, the sound is unbearable. Interpreter can't hear. So the competition commission was an advisory authority, or what was the status of this competition commission? So the decision of the competition commission regarding candidates had any impact on the results of the competition or not? So was it more of a recommendation nature? So answering the questions of a rapporteur, you said that as the competition commission was not a subject of power authorities and you were not an official who shall be subjected to general principles, you were quite free in your acting and your conduct during the voting procedure, including the timing after voting. So that's why I'm asking you about the status of that competition commission. Thank you. Thank you for your question. It's quite a hard question. Unfortunately, right now I can't answer it because I don't remember the provisions of the law on ARMA. Then tell me, what about other commission members? Did they have the same perception of the voting procedure? Did they also think that this ranking voting would have no influence, no impact on future events? Or did it was only your perception? You know, I can speak only about myself. No. Sorry. So you worked at the commission, that's a panel, yeah, of different members. There was some kind of an atmosphere. So what was general perception, different general atmosphere? So if you think that you were misled, sorry, I didn't think that I was misled or confused, no. But okay, you thought that procedure voting was aiming at identification of ranking of different candidates. And what about other commission members? How other commission members perceive that procedure? You know, when it happened, so before having that session, we didn't have any winner at all. You know, before having broadcasting, you know, live streaming, we had also discussed what we are going to have, what so on, and we hadn't had any finalists at all. And then, based upon the voting results, we have a candidate who has enough votes to be a winner. We were surprised, and it was so good. Okay, we have a winner. It's great, and correspondingly, everyone agreed. Yeah, it's enough. The competition is over. And then afterwards, when I started to go back in reverse, I started calling commission members, communicating with each of them individually, and they started asking me, Dmytro, what are you doing? What's happening? And I said, let's look at the procedure. There was a ranking voting, but we didn't have a voting according to the rules of procedure. We didn't vote only once for each, we didn't give our in favor vote only for one candidate. So let's call another session while the minutes of the session is not signed. But what about the other commission members? Did they express any reactions? Yeah, in our communication, I didn't manage to convince everyone that we need to have to convene another additional session. Yuri Butusov supported me. I don't remember name of a person, of a foreigner, a male foreigner who also supported me. The chair of the commission also supported me, but some colleagues, the deputy chair, didn't support me, but he even, not only didn't support me, but he's also called me unprofessional. So when you provided replies, yes, to the questions. It was so we just tried to realize whether you were aware about the status of the commission and what was the principle and the general status of the commission which covered your activities. How? What was it? What was your status, the status of the commission? I want to say that what I'm recalling right now is that the decision of the competition commission that was submitted to the cabinet of ministers was of the recommendational nature. Thank you. Alexei, Sergey, over to you. Yeah, I will try to be concise also. As far as I've got your point, so the rules of procedure of the competition commission didn't envisage to have a ranking voting. No, it didn't envisage. So the fact that you are going to have a ranking voting, it looks like that you had agreed upon it before the official session, before the broadcasting. Yes. So during the broadcasting, you said that the list was in alphabetical order. So did you stop yourself at some point? What do you mean here? Did you stop yourself? No, I mean the following, that you have a list of candidates in alphabetical order. Yes, Olena Duma, her surname starts with D. Yes, so it means that candidates with other surnames shall be before her or after her. No, we continued. We went through the whole list of candidates. Thank you. Dmytro, I had two questions to you. The first question, that's regarding this part about the joint session, about your capacity to work at the HACC. Considering your FB post and that you were a member of the PIC and you are active citizen, you consider yourself as an active representative of the public society, you represent the society, the public also in that competition commission. So do you feel that you are subject to certain professional defamation, you know, the public dimension, that being a judge, you would be more a representative of civil society rather than a judge? Because, you know, just to follow up question from Mr. Robert, so you respond very acutely and sharply to different comments and posts of CSOs and different associations. And of course, such posts also will be about you if and when you become an HC judge. I would like to hear your reply because, you know, these are two different tasks, and I hope that you understand it. You know, the task of civil activist and of a judge. Do you feel that you are subjected to this defamation? Will you be able to avoid such defamation in professional activities?
Thank you, Mr. Sari, for your question. Very interesting question. I feel professional defamation probably because of the fact that I'm a lawyer. Why? Because what do I have to encounter in my work? Mostly I work in the anti-corruption court. The cases that I have are usually not high-profile cases, but still, anyway, they are covered in Telegram channels, mass media, etc. And in these cases, there is quite a prevalent opinion advanced even before we move on to the consideration of the case on the merits. My defendants are being portrayed as corruptionists, as perpetrators of crimes, and I have a tendency to distrust anyone and to check everything. I do not even fully trust my client. So my client is informing me something, but I have the right to check it briefly. That's why probably because of being the attorney, I have sort of a deformation with respect to the fact that some civil society organizations, which I really respect, but in my opinion, they cross the line sometimes in how they criticize, what they communicate. And because of that, I have some sort of irritation because of that, of how they are doing and what they are doing. Okay, thank you. And my second question, given that you were a member of PIC, 2.0, as we call it. It's well known that back then, in 2018, 2019, there was, since when? Since 2019, yes. Okay. No, it was the end of 2018. Okay. But back then, there was the acute stage of the conflict of the PAC with the HQCJ. It's a well-known fact that the PAC back then sort of protested and left all procedures of qualification evaluation. Please tell me, did you support such a position of PAC back then? And in any case, if yes or if no, have you changed your attitude that it was a mistake by PAC back then? Or tell us about your attitude. I will not push you towards some specific answer. I do not remember whether we voted on that matter, frankly speaking, but I remember for sure that I was against these harsh actions, because I believe that just to leave the conflict, to stand aside and say we are like in white and everyone is bad and we are good, it's the easiest way. But no, work has to be done. In any conflict, okay, the Russian-Ukrainian war is not showing that it's impossible, but in any conflict normal for people, parties can be put at a table. You can find out about their claims, to find something in common and to overcome these issues. That's why I did not approve of that decision. I just don't remember whether we voted for it or not, but we had discussions about that for sure. Thank you for your answer. Thank you, colleagues. Okay. Good afternoon, Mr. Dmytro. I have a small question to you about all of this procedure of voting that you had. Tell me, please, did this internal ROP set out some special procedure how it could be corrected, or the only way was at least to do what you did? That's firstly. And secondly, did you try after that to somehow improve that procedure so that you could reach a fair and correct decision? Thank you for your question. The rules of procedure set out that upon demand, I cannot tell you for sure, but several members of the commission, either the secretary or the chair, you could convene an urgent additional meeting. And that's why I started calling other members of the commission. I managed to convince 3 other commission members, or 3 in total. I managed to get sufficient number of commission members in order to initiate this additional official meeting. So yes, the ROP had this opportunity. I used that. With respect to the improvement of the procedure, I would like to tell you that I tried to work on that since the very beginning. I will explain. When the competition started, I was addressed by representatives of Transparency International with the suggested draft rules of procedure. We worked on that jointly. They explained to me which ideas should be contributed, how to update that ROP. I thought that some ideas were good. I added something for myself. For example, it was said that some documents have to be published, that it's impossible. Please. Yes, I worked on that. And there is a broadcast at YouTube. I put up for voting of commission members, and I suggested to adopt the ROP in the new version, but I could not convince the majority of commission members to do that. Okay, thank you. Colleagues, do we have any other questions? Olena, please. Summarizing question. As a result of our interview, maybe I will name some small facts that you have voiced and how you can explain that. You said that you wanted to become a member of the parliament, but you abandoned the idea because you were threatened with murder. You wanted to get the attorney's license, but you were told that you were not going to get it because of the conflict. You found an easier way. You found another city to get your attorney's license. You voted contrary to the rules of procedure in the way that we discussed. At the same time, you are referring to your lack of experience. But given the lack of experience, still, you agreed to take part in this very important competition. So tell me, please, this fact, these features, won't it prevent you from as a judge of the High Anti-Corruption Court, will you be strong enough to resist the impact, pressure from the civil society, maybe of political parties? Have you changed since then? Thank you. Very good question. As any human being, I'm not perfect. I will ask you to be very concise. Okay, I'm not perfect. I'm growing. I'm working on myself. I'm making mistakes. I'm working on these mistakes. I do not see any problem with admitting my mistakes and discussing them publicly. Secondly, during this interview, we were talking only about problematic issues from my biography, but we were not discussing my professional work as the attorney, about those instances when I was displaying persistence in my intentions. I can tell you the only thing. You cannot even imagine how difficult it is when you're a defense attorney. When the pre-trial investigation body is suggesting them to conclude a plea agreement, which do not envision imprisonment of the person, but you, as the defense attorney, understand there are very good chances to get the verdict of acquittal. You believe that the person is innocent. Just imagine which responsibility it is for you as the defense attorney to have courage to advise to your client, to explain to your client that it's better not to enter the plea deal. I was asking about slightly different. Will you have an inclination towards being subject to pressure from the civil society and political parties? Yes. Okay. And just to summarize, so based on what you've said, as far as I understand, the work of the attorney is much more difficult than the work of the judge. No, I do not believe that. I believe that any legal world is very difficult. Okay. Thank you. Okay, then, colleagues. All the questions have been asked. Thank you. Dear members of the PCAE, maybe you have some additional questions to the candidate.
Norman and Mary? No? Okay.
Okay, thank you, Mr. Dmytro. Now you have up to 1 minute to address us with concluding remarks. Maybe you would like to add something. Thank you. The only thing that I would like to say, and I will kindly ask the Commission about one thing only. With me or without me, please fill in all 23 vacant positions in the High Anti-Corruption Court, even regardless of whether I work as the judge or as a defense attorney. In both cases, it will be much easier for me, because this court is overloaded, and I see in my proceedings that it has started impacting the work, because cases are being considered slower. That's bad. That's my only request to you. Thank you. Okay, thank you, colleagues. Thank you for your participation. The interview is over.